With Dua, allow me to introduce Dorothy. Dorothy is 71 years young. She resides solo in a residence she has possessed for 34 years. Her spouse departed 3 years prior. Her closest neighbor lives a quarter-mile down the street. She has maintained a lawfully registered weapon in her dwelling for over 20 years, not because she feels fear, because she stays ready, because she is a liable, independent lady who decided long ago that her security was her duty. Last year, her state enacted a fresh set of transport limits, fresh license needs, fresh instruction orders, fresh costs, fresh renewal schedules. Dorothy's daughter phoned her saying, "Mom, I think you must surrender the gun. The fresh statutes say you must recertify. You need a fresh license. You must attend a class." Dorothy nearly trusted her. But here is what Dorothy's daughter did not understand, what Dorothy's local police force did not inform her, what the news station that reported the fresh statute never once stated. Dorothy was lawfully excluded. Every single one of those fresh demands, the recertification, the fresh license, the compulsory instruction class, the costs, none apply to her, not due to a loophole, not due to a technicality, due to specific, clearly defined federal and state legal safeguards that exist for elderly weapon possessors, safeguards that most elders in this nation have never been informed about. I am an attorney, and I am stating right now, if you are an elderly weapon possessor or if you cherish someone who is what I am about to reveal in this clip could be the most vital legal data you obtain this year, because the folks who wish to seize your weapons are relying on one thing above all else, that you lack knowledge of your privileges. Here is what is occurring across this nation right now and why it concerns specifically you. In the recent several years, scores of states have enacted fresh weapon transport statutes, fresh license frameworks, compulsory instruction needs, recertification schedules, raised costs, age-based capability limits. The list continues expanding, and each time a fresh statute passes, the reporting is identical. Here is what altered. Here is what everybody must perform now. What that reporting almost never contains is this. Here is who is specifically excluded, and elders are being targeted by this information void in a manner that is not accidental. Consider who is most prone to willingly relinquish a lawfully possessed weapon based on a misconception of the statute. It is not a 30-year-old who has an attorney pal he can ring. It is not a 45-year-old with time to investigate online. It is a 70-year-old who trusts what she hears on the news, who accepts what a kind relative tells her, who does not wish to inadvertently violate a statute, who would prefer surrender her weapon than risk being on the incorrect side of something she does not fully comprehend. That is the weakness that is being exploited, not by evil intent in every instance, but by a steady failure to convey the full legal image. Elderly weapon possessors in this nation have privileges that are specifically and intentionally safeguarded. Federal statute, state exclusions, disability adjustment needs, age-based exceptions that exist in the legal code right now. And the overwhelming majority of elders who require this data have never once heard it. This clip is going to alter that. If you are an elderly weapon possessor, or if you have a parent, a grandparent, an aunt, or uncle who possesses a weapon lawfully and is anxious about these fresh statutes, this clip is for them. Distribute it before you do anything else, because the data in the next 15 minutes could be the distinction between someone retaining their legal weapon and surrendering it based on a total misconception of the statute. Press subscribe immediately, because this channel exists to ensure the full legal image reaches the folks who require it most. Now, let us enter the 6 things every elderly weapon possessor must understand. Let me begin with the safeguard that applies most directly and most instantly to elderly weapon possessors across the nation. Many states that have enacted fresh transport license needs have built into those very statutes an exclusion for weapon possessors above a certain age, typically 65 or older, who have held a valid license for a continuous span of years. In these states, those elders are not required to recertify, retest, or pay fresh costs to maintain their transport privileges under the fresh statute framework. This is not a rumor. This is written into the codes of multiple states right now. Here is why this exclusion exists legally. When a legislature enacts a fresh weapons statute that imposes needs on existing license holders, courts have consistently examined whether those needs place an excessive burden on people who already established their compliance with prior statute. For elders specifically, there is an extra layer. Courts have looked at whether compulsory recertification needs that involve physical and mental testing components create a discriminatory barrier for older Americans who may have physical constraints that have nothing to do with their ability to safely own and store a weapon. In several states, the legislature addressed this proactively by writing the age-based exclusion directly into the fresh statute. Now, here is the critical action step. You cannot assume your state has this exclusion without verifying it. What I am telling you is that these exclusions exist in many states and that most people do not know to look for them. Your task right now, before anything else, is to go to your state's official Attorney General website or your state legislator's official code and look up your state's transport license statute. You are looking for language that says something like exclusion for license holders over the age of 65, or waiver of recertification needs for elderly license holders, or grandfathered license status for long-term holders. If you do not know how to find this yourself, call a weapon rights attorney in your state, not the police force, not a weapon shop, because the stakes of getting this wrong are too high for anything less than accurate legal data. This is the safeguard that almost nobody discusses, and it is one of the most powerful tools available to elderly weapon possessors who face fresh compulsory instruction needs. Here is the legal foundation. The Americans with Disabilities Act. The ADA prohibits discrimination against individuals with disabilities in programs, services, and activities provided by state and local governments. Many fresh state weapon instruction mandates are government-run or government-approved programs, and many elderly weapon possessors have disabilities, mobility constraints, hearing impairment, visual impairment, chronic pain conditions that make compliance with standard instruction course requirements genuinely impossible or unreasonably burdensome. Under the ADA, those elders are entitled to reasonable accommodations. What does that mean in practice? It means that if a state mandates a weapon instruction course that requires physical activities that an elderly person with a documented mobility constraint cannot safely perform, that elderly person has a legal right to request an alternative accommodation, an adapted instruction format, a written examination in place of a range qualification, a home-based assessment by a certified instructor. The state cannot simply say your disability is unfortunate, but the requirement stands. Under federal statute, they have an obligation to provide reasonable accommodation. Now here is the trap that comes with this safeguard. Accommodation does not happen automatically. You have to request it specifically in writing through the correct process, and you have to be able to document the disability that forms the basis of your request. This means two things. First, if you or an elderly person you love has a qualifying disability and faces a fresh instruction mandate, talk to an attorney before you do anything else. Do not simply skip the course and hope for the best. Do not willingly surrender the weapon. Get legal advice about the accommodation process in your specific state. Second, get your documentation in order. A letter from your physician describing the relevant constraint, medical records if applicable. The stronger your documentation, the stronger your accommodation request. The ADA is federal statute. It applies in every state, and it is a shield that most elderly weapon possessors have never been told they can use. Here is a word you have probably heard before, grandfathered. And here is the problem. Most people have a vague sense of what it means without understanding exactly how powerful it can be and exactly where it stops protecting you. When a fresh weapons statute is enacted, many of those statutes include what is called a grandfather clause. That clause says people who were already in compliance with the prior statute before this fresh statute took effect maintain certain rights under the old rules. For elderly weapon possessors who have held valid licenses for years or decades, this matters enormously. Here is a real example of how this plays out. A state enacts a fresh statute that requires all transport license holders to complete a fresh 12-hour instruction course and recertify on a range before their next renewal. But the grandfather clause in that statute says license holders who have held a continuous valid license for 10 years or more are exempt from the instruction requirement and must only complete the standard renewal paperwork. Dorothy, who has held her license for 22 years, falls directly under that grandfather clause. She owes nothing to the fresh instruction requirement. But here is exactly where people go wrong with grandfather clauses, and this is critical. A grandfather clause protects what you already had. It does not automatically extend to new things. If Dorothy lets her license lapse, even for 30 days, and then tries to renew, she may fall outside the grandfather clause and be subject to the full fresh requirements. The protection depends on continuity. This means that the single most important action any elderly weapon possessor can take right now, regardless of everything else, is this: do not let your license expire, even if you are confused about the fresh statute, even if you are not sure what is required, even if you are thinking about whether you even want to keep carrying. Keep the license active while you figure it out. Because once you let it lapse, you may lose the grandfather protection that was the very thing keeping the fresh requirements away from you. Renew before you understand everything. Understand everything before the next renewal, not the other way around. This is the confusion that causes more unnecessary weapon surrenders than almost anything else I see. When people hear about fresh transport statutes, fresh license needs, fresh instruction mandates, fresh restrictions on where you can carry, they sometimes conclude that if they cannot or do not want to comply with the fresh carrying requirements, they must give up their weapon entirely. That is completely and absolutely wrong. Your right to keep a weapon in your home for self-defense is a separate constitutional right from your right to carry that weapon in public. The Supreme Court established this clearly in District of Columbia versus Heller. The right to keep a weapon in your home for self-defense is a fundamental constitutional right that does not depend on any license, any training certification, or any carrying statute. A fresh carry license requirement affects your right to take that weapon outside your home. It does not affect your right to have it inside your home. A fresh instruction mandate may affect whether you can renew your carry license. It does not require you to surrender a weapon that sits legally in your home. Dorothy does not carry. She does not go to the mall with a holstered weapon. She keeps her gun in her nightstand because she lives alone on a rural road and she wants to be able to protect herself in her own home. No fresh carrying statute touches that. None. Her home storage right is protected by the Constitution of the United States, and it exists independently of every license requirement, every instruction mandate, and every fresh restriction on public carry. If you or an elderly person you love owns a weapon for home protection and has no interest in carrying it publicly, the fresh carrying statutes that have been passing across the country are largely irrelevant to your situation. You need to know they exist. You do not need to surrender your weapon because of them. Know the difference between carry rights and home rights. They are not the same legal question. Fresh license requirements almost always come with fresh fees. application fees, instruction fees, range qualification fees, renewal fees, and for many elders living on fixed incomes, the financial burden of those fees is itself a barrier to maintaining their legal weapon rights. What most people do not know is that many states have built financial hardship waiver provisions into their license fee structures. These waivers allow applicants who can demonstrate financial hardship, typically through documentation of fixed income status, Social Security income, or income below a threshold, to have license fees reduced or eliminated entirely. This is not charity. This is a legal mechanism specifically designed to prevent financial barriers from stripping low-income Americans of their constitutional rights. Courts have recognized that if a constitutional right can only be exercised by people who can afford a fee, the fee itself becomes an unconstitutional barrier. For elderly weapon possessors on fixed incomes, this waiver process can be the difference between maintaining a legal carry license and losing it, not because of a legal disqualification, but simply because the cost became impossible to bear. Here is how to access this safeguard. When you apply for a license renewal in your state, specifically ask the permitting authority whether a financial hardship waiver is available. Ask for the process and the documentation required in writing. Then gather your documentation, your most recent tax return, your Social Security income statement, any other relevant financial documentation, and submit the waiver request formally alongside your application. If your state does not have an explicit waiver process and you believe the fee structure creates an unconstitutional barrier for you specifically, that is a conversation for a weapon rights attorney, because there is case law supporting the argument that prohibitive license fees violate the Second Amendment as applied to low-income individuals, and that argument has succeeded in court. Your right to keep and bear arms does not expire because your income is fixed. Do not let a fee stand between you and a protection that the Constitution guarantees. This final safeguard is perhaps the most practically important one in this entire clip, because all the legal rights in the world mean nothing if you do not know how to respond when someone in authority tells you something that is incorrect. And it happens. It happens more than it should. An officer at a traffic stop tells an elderly weapon possessor that her license is no longer valid under the fresh statute. A police department employee tells an elderly person that he needs to re-register his home weapon under the fresh requirements. A well-meaning but legally misinformed family member tells their elderly parent that the fresh rules mean the gun has to go. None of these people are necessarily lying. Some of them genuinely believe what they are saying. But belief is not law, and in the gap between what someone in authority tells an elderly weapon possessor and what the law actually says, weapons get surrendered that should never have been surrendered. Here is your protocol when someone tells you that your weapon rights have changed or been eliminated under a fresh statute. Step 1. Do not surrender your weapon on the spot, not to a police officer who tells you your license is invalid, not based on a phone call from a government office, not based on anything short of a court order. Your weapon is your legal property. Surrendering it voluntarily is a decision you cannot easily undo. Step 2. Write down exactly what you were told. Who told you when, what specific statute or requirement they cited. The more specific your notes are, the more useful they are to an attorney. Step 3. Contact a weapon rights attorney before you do anything else. Not tomorrow, today. Because in most states, even if there is a legitimate legal issue with your license or your weapon, you have a process available to you: an appeal, a waiver request, a correction of a clerical error that an attorney can navigate on your behalf. But those processes have deadlines, and voluntarily surrendering your weapon before you understand your options can permanently eliminate some of them. Step 4. Contact your state's Attorney General office or a weapon rights organization in your state. Organizations like the Second Amendment Foundation and state-level weapon rights groups have legal resources specifically designed to help weapon possessors who are facing incorrect enforcement of fresh statutes. You work too hard for too many years maintaining your legal weapon rights to surrender them based on incorrect information. The law protects you, but only if you use it. Let me bring all 6 safeguards together for you right now. The age-based license exclusion means many elders do not need to recertify under fresh statutes, but you must verify your specific state's language. The ADA accommodation right means compulsory instruction requirements cannot legally be applied to elders with qualifying disabilities without reasonable accommodation. The grandfather clause means continuous license holders are protected from fresh requirements, but only if they keep their licenses active and do not let them lapse. Home storage rights are completely separate from carry rights, and no fresh carrying statute touches your right to keep a weapon in your own home. Financial hardship waivers mean license fees cannot legally become a barrier to your constitutional rights. And when law enforcement gets it wrong, and sometimes they do, you have a clear protocol that starts with not surrendering your weapon and ends with an attorney. Dorothy kept her gun, not because someone bent the rules for her, not because she got special treatment, because she found out what her rights actually were. And her rights were clear. They were established, and they were being violated, not maliciously, but through a complete failure of information. If you are an elderly weapon possessor, or if you love one, share this clip right now, not later, right now, before you close this screen, because the person who needs this information most is probably not searching for it. They are trusting the wrong sources, and they may be one phone call away from giving up a legal right they have held for decades. What if an officer shows up at your door and tells you that you are required to surrender your weapon for inspection? Check out the next clip where I break down exactly what your rights are when police come to your door and the specific words you say to make sure your rights are protected. I will see you over